Good morning to you all. On behalf of the Human Rights Committee of Bar Association of Sri Lanka, it is my great honor and privilege to welcome you to this important regional conference, Learning from Our Neighbors. We are deeply grateful for your presence here today as we bring together some of the finest legal minds, judges, and human rights defenders from across South Asia. This gathering is not only a professional forum, but also a reminder that the challenges of justice and human rights are shared challenges, and our progress depends on learning from one another. We are honored to extend a warm welcome to our respected guests who have joined us for this important gathering. We are privileged to have with us Mr. Rajiv Amarasuriya, President of the Bar Association of Sri Lanka, will be joining us shortly. Admar Andre, the Resident Coordinator of the United Nations Organization in Sri Lanka. We are equally honored to welcome Honorable Justice Rohanda Abeysurya, President Council and President of the Court of Appeal, whose presence added great significance to today's proceeding. We also take pride in welcoming Mr. Lakshan Dias, Senior Counsel of Supreme Court of Sri Lanka and Chairperson of Human Rights Committee of the Bar Association of Sri Lanka, and along with our esteemed colleagues from South Asian for Human Rights. At this point, allow me to extend our warm welcome to the eminent judges and respected lawyers join us from South Asia and beyond. Your presence greatly enrich the regional dialogues and strengthen the exchange of experience we seek to foster through this conference. Ms. Hina Jilani, a pioneer of human rights law in Pakistan and co-founder of several landmark institutions, including AGHS Legal Aid Cells and the Human Rights Commission of Pakistan. Her decades of fearless advocacy inspire all of us. And Justice Hari Prasad Fuyal, a respected justice of the Supreme Court of Nepal, whose career has combined constitutional experience, scholarship, and commitment to strengthening the rule of law and human rights. Justice Deepanand Swamy, High Court Judge of Maldives and the first woman appointed to the Criminal Court of Maldives, is the true pioneer for women in the judiciary. Mr. Calvin Gonsalves, a senior advocate of the Supreme Court of India and founder of Human Rights Law Network, who strategized public interest litigation, has transformed the landscape of social justice in India. Mr. Anik Haq, the senior advocate and additional Attorney General of Bangladesh, is a leading figure in both advocacy and legal reforms with significant contribution to the telecommunication and commercial law. We are honored to have each of you with us, and we thank you for bringing your wisdom, experience, and commitment to this conference. Colleagues, friends, the purpose of this gathering is to create a space where we can reflect together on the evolving challenges human rights laws in South Asia. Our region, rich in legal diversity and constitutional traditions, but is also faces common struggles such as balancing national security with the individual rights, protecting minorities, addressing custodial death and abuse of authorities, and strengthening regional network for collecting advocacy. Through comparative analysis and encroachment of security system in the space of individual rights, we hope to not only understand these issues, but also identify strategies that are practical, transferable, and sustainable across the borders. This is where our strength lies, in learning from one another, and in standing together, the value of justice, fairness, human dignity are under threat. It is also my hope that this workshop will plant the seed of lasting collaboration beyond the formal sessions, may we use this opportunity to build trust, to mentor young lawyers, to share ideas informally, and to create a culture of regional solidarity that will carry forward long after we leave this room. In closing, I warmly welcome you once again to Sri Lanka and to this collective journey of reflection, dialogue, and growth. Let this conference be beginning of deeper partnership and renewed commitment to human rights across the Asia. Thank you, and I wish you all the engaging and fruitful discussion.
Thank you, Ms. Sivaraja, for setting the tone for this important gathering. Next, we are honored to listen to our keynote address on judicial accountability for upholding human rights, lessons from South Asia. The keynote will be delivered by none other than Ms. Hina Jilani, lawyer at the Supreme Court of Pakistan, former Special Representative of the United States Secretary General on Human Rights Defenders, and a distinguished member of the Elders. This session will be chaired by Mr. Lakshan Dias, Senior Counsel of the Supreme Court of Sri Lanka and Chairperson of the Human Rights Committee, BSL. Ladies and gentlemen, please join me in welcoming Ms. Hina Jilani to deliver the keynote. The stage is over to you.
Good morning, ladies and gentlemen. I will take a few minutes to give a very brief introduction about Ms. Hina Jilani. I will start my introduction about an incident. A few years ago, a Sri Lankan was beaten to death in a rural or semi-rural area in Pakistan. And we were worried in Sri Lanka that what's happened for that Sri Lankan. And all of a sudden, we saw that there were protests in Lahore, and we found that Hina also there in the protests. Being a very senior advocate of the Supreme Court of Pakistan, that is the quality of a human rights defender. Wherever and whenever it's necessary, come forward for the protection of the human rights of across the borders of everybody. So with that note, while thanking Hina for her courageous presence for the protection of the human rights, I would like to introduce Hina. Hina Jilani is a lawyer at the Supreme Court of Pakistan and human rights defender from Lahore. She co-founded AGHS Legal Aid Cell, within bracket ALAC, Pakistan, and first all-women law firm, its first legal aid center, and Women Action Forum, an advocacy group to campaign against discriminatory legislation. She is also one of the founders of the Human Rights Commission of Pakistan. She's also helped set up a Dastak, an organization, a women's shelter which is committed to raise awareness for human rights and protection for women. Throughout her commitment as a human rights defender, she has faced numerous threats in her life. I mean, doing human rights in Pakistan and in all over Asia, all over South Asia, is not an easy job. So Hina took that challenge, and she continued to be a human rights defender, and she's a very strong member as well as former chair of the South Asians for Human Rights, which is a group of human rights defenders, also initially co-founded by former Prime Minister of India, Indra Kumar Gujral, and Azma Jahangir, and many other South Asian human rights defenders. So Hina has huge list of credentials of her, and that includes she's the former United Nations Special Representative of the Secretary General on Human Rights Defenders from 2000 to 2008. She was also a member of the International Commission on Inquiry on Darfur in 2006. She was a member of the United Nations Fact-Finding Mission to Gaza conflict in 2009. Hina also co-chaired the World Health Organization Office of the United Nations High Commissioner for Human Rights, high-level working group on health and human rights for women, children and adolescents in 2017. In 2013, Hina became a member of the Elders, a group of independent global leaders found by Nelson Mandela. Her courage, commitment, and contribution towards human rights is immense, and we are privileged to have Hina with us and to listen to her experience, her thoughts, and her contribution. Hina, the podium is yours.
Good morning, ladies and gentlemen. First of all, let me thank the Bar Association of Sri Lanka and the Human Rights Committee of the Bar for inviting me to participate in this very significant re-emergence of the urge amongst lawyers in particular and the civil society to reactivate our human rights networks in the South Asian countries. It is a great privilege for me also to be speaking to a gathering which has judges, lawyers, human rights defenders who have worked for a long time on the respect and promotion and protection of human rights in this country. Let me begin by saying that the topic that I have been given to speak about, and particularly the title of this conference, Learning from Our Neighbors, has a particular resonance in the South Asian context. We have similar history and the same kind of baggage of history that we carry on our shoulders. We as lawyers have been committed for a long time in Pakistan, in India, in Nepal, in Bangladesh, and the Maldives to bring about a change which not only sets our politics in the right direction, but in a direction where the support and respect for the rule of law is not only written in our constitutions, but is actually followed to the advantage of the population for whose benefit the whole concept of freedoms has developed. We know, and I don't have to explain that in great detail to the gathering here, we know that while governments have learnt all the wrong lessons and follow very readily all the wrong practices in South Asian countries and adopt them as their policies, we as human rights defenders have tried to challenge that approach. We have tried not just on the streets through visibility of our protest, but also in the courts as well. And you all must have experienced, as I have in my 40 odd years of struggle as a human rights defender, that particularly human rights defenders who are lawyers and are trying to promote human rights even through our courts, we always have a judgment call. Is it an issue that we feel we will successfully go through on the streets, or is it something that we must take to the courts? Sometimes we have erred in this judgment. And when we have gone to courts, we have given way to the stamp of authority and legitimacy to all the wrongs that we have actually been fighting against. And one of those examples I very regretfully remember is the example in the 1980s when a very discriminatory and harsh law was passed in the name of religion by a military dictator that was targeting women, their individuality, and their status as citizens of the country, and in many ways demolishing the concept of equality before the law and equal protection of the law to women in our country. We had warned many of our colleagues who were lawyers, women lawyers, that this is not something that we can successfully fight in the courts of law at that time, who were very much under the influence of a dictator, a military dictator. And we took to the streets. Unfortunately, some of our colleagues didn't understand how sensitive the environment was at that time. And one of our women lawyers filed a petition challenging these laws in the High Court. She lost, obviously, because the courts we knew were not independent of influence of the military at that time. The result was that those laws got the legitimacy through the courts. Now, the question that I've been asked to answer is, what is the accountability of the judiciary in terms of promotion and protection of human rights when they deviate from the very constitutional principles that they are supposed to enforce? These are questions that I think many of us sitting in this hall today are still asking ourselves. I, as a lawyer and as a human rights defender, have been striving in order to make sure that at least even during very difficult political times, the judiciary will stand behind the constitutional guarantees of fundamental freedoms and human rights. I cannot say that the judiciary did that and stood behind democracy, the rule of law, or the exercise and realization of human rights as an institution. Yes, we have had some very good human rights judgments in many of our countries. But was that because of individual judges, or was it because the institution actually built walls around themselves to protect them from influences that affected their independence and their commitment, not just to human rights, but to democracy and the rule of law? I'm afraid in none of the South Asian countries can I see the institutional capacity, tenaciousness, and protection of their own independence amongst the judiciary. These are lessons that we can't pick and choose and learn from our neighbors, where we find some good judgment and say, oh, this is a good judgment, and we hope that our judiciary will follow these. There was a time when you could cite judgments, not just from the region, but also globally, that supported human rights, that supported the rule of law. And in that sense, were giving a strength to a global world order that was based on principles that are universal. So that universality of human rights, of certain principles of the rule of law, and a rule-based order, I don't think that our judicial minds have yet been able to grasp the significance of how national tenacity in upholding human rights can help and contribute to a global world order that is based on the rule of law. And you can see that now in the current situation that we look at around the world. And here I would like to draw your attention for a minute to the Universal Declaration of Human Rights. The first article of that declaration says that every human being is endowed with reason and a conscience. As far as I'm concerned, I'm really confused now. And what this principle has said in the Universal Declaration confounds the belief that every human being is endowed with reason and conscience. You look at what is happening in Gaza. You look at how the multilateral system has been totally marginalized, with not just previously we'd seen dictators and authoritarian systems and authoritarian regimes within national boundaries. Now we see dictatorship at the global level. Today, I feel that the multilateral system in this age of conflicts and the first large genocide occurring in Gaza, the multilateral system would have been extremely useful and of significance. My personal feeling is that there has been in the past few years, and especially in this in the 21st when the 21st century began, there was a deliberate attempt to marginalize the multilateral institutions. So today we see that there is one person who is the Security Council, has taken over the role of peace and security globally that the Security Council should have played. There is one person who now has taken over the role of the WTO to set the standards of how countries conduct their business. There is one person now who thinks he can replace the multilateral institutions that have been trained for a long time in humanitarian assistance. So the whole humanitarian system of the United Nations has been disturbed. So these are things that we must realize that are happening not only because how governments act in their international relationships or in their diplomacy between states. These are things that are also happening because what we are seeing develop within our own boundaries. Are we respecting institutions? are the institutions playing the role that they are supposed to play? Today, our parliaments in the South Asian region in particular are in disarray. The legislature is not working in a manner that it should to create a framework of laws that protect the people. Most of us now understand that the source of laws is not protection and increasing the capacity of the state to its primary responsibility, which is the responsibility to protect. It is this legal framework that we see in the recent years developing in many countries where there has been collaboration of the legislature to bring in laws that empower the state to increase their capacity to control. And that, I think, is something that we as lawyers have readily challenged. I don't think there has ever been any lack of energy amongst the lawyers, the human rights defenders, and even political workers in challenging these laws. But what kind of response have we had? As I said earlier, individual judges have given good judgments, and I can cite many from all the South Asian countries. But at the same time, do those judgments now hold a ground which none of the higher courts in our countries can deviate from? Are those principles followed? And let me give you an example of Pakistan. In Pakistan, military takeovers have been frequent. And every time, it is the judiciary that has given legitimacy to a military coup, except for once. And that was in the 1970s, when a judgment, which is very well known as the Asma Jilani case, not that Asma Jilani was a lawyer at that time, she was just a petitioner, and this case had been filed to challenge the detention of my father by a military ruler. This was the first time that the Supreme Court of Pakistan said and negated the Kelson theory, saying whether a military coup is successful or not is irrelevant. Carrying out a military coup against the constitutional provisions is always an illegal takeover of power. What happened to that judgment of the Supreme Court? A few years later, another coup takes place, and the Supreme Court totally backs that military takeover without even referring to a Supreme Court judgment which was binding on them. So these are some of the things that convince us that these sparks of hope that we see in terms of good judgments are only sparks, and they lose their light. And the institution does not bind itself to those principles. How do we hold judges accountable? Has also become a very controversial topic of debate amongst the bar associations in particular. What kind of mechanisms can be created, firstly for the appointment of judges, and secondly for holding them accountable? It is controversial, and several countries have adopted diverse mechanisms. and different kinds of mechanisms for appointment of judges and for the accountability of judges. I again give the example of Pakistan because that's the system I know better than any other. There has always been a debate. Who appoints judges? Does the judiciary have a primacy in the appointment of judges? Does the parliament have any say in it? Or should the parliament have any say in it? Or should it be a kind of hybrid mechanism that brings in the bar, that brings in the parliament, that brings in the judiciary, and also includes some civil society organizations? We've never settled that point, even now. Pakistan gained independence in 1947. 78 years ago, I think, 75 years. We have yet not been able to decide which is the best system for the appointment of judges. And at the same time, we have still not been able to decide what the Constitution should say in terms of judicial accountability. In my mind, thinking as a human rights defender and a human rights lawyer, all kinds of misconduct includes violation of human rights and judgments by the apex court in my country that deliberately violate human rights. It's not a matter of incompetence. When a person reaches the Supreme Court as a judge, they know fully well what the constitutional requirements are. And yet, the deviation from those principles in order to protect the human rights of the population, and especially the human rights of the marginalized and more vulnerable communities or populations, to do gender justice, to do social justice through legal judgments, is still missing as a core value of the institution of the judiciary. As I have said before, we have good judgments. In Pakistan in particular, there have been very good judgments on environment. There have been good judgments on control over the development policies of the executive so that the social and economic rights of the more vulnerable communities can still be protected. But those judgments are not necessarily influencing the institution of the judiciary itself. And I'll give you another example. One development project was found to be environmentally harmful and violating the social and economic rights of a certain section of the population living in an area where a development project was taking place. The High Court judgment examined all aspects of that development project and held it to be in violation of the rights of the people in that area, and environmentally certainly harmful to people's right to a good, healthy environment. In Pakistan, and I don't know, I think other colleagues from other countries will perhaps enlighten us on this. Civil and political rights are clearly specified as fundamental rights in a particular chapter of the Constitution, enforceable by the courts. Social and economic rights are largely dealt with under the principles of policy, which have very limited enforceability by the courts and can only be enforced if the state is found to have sufficient resources to fulfill that obligation imposed on them by the principles of policy. So we are really, the scales are not equal in terms of civil and political rights and social and economic rights. But what has our judiciary done in some of the landmark judges that we appreciate to this day? They have used the principles of policy, for instance, to interpret the fundamental rights that are enshrined in the Constitution. One judgment in particular interpreted the right to life to give the status of fundamental right to environmental protection, fundamental right even to women. We have an abortion law in which women can only have access to abortion if the life of the mother is threatened. In a case that I did some years ago, a mentally disabled teenager was raped, and the doctors prescribed abortion as a remedy for her because she was neither able to take the rigors of pregnancies or raise that child. The Lahore High Court interpreted the right to life to say the right to life does not mean death. It also means the quality of life, and ordered a board of doctors to examine the young woman and to give her the remedy of abortion. So these are some things that judges can do. But at the same time, because of religious issues and the upheaval that judges fear from the religious lobby, that judgment was never taken forward. I'm thankful that at least it was not disapproved by the Supreme Court. So it's still lying in the High Court, but nobody has been able to use that as a precedent to make sure that in individual cases, we can overcome the limits on the law of abortion that places limits on the law of abortion in Pakistan. Now, I would like to bring another example to you. When I mentioned the religious lobby, it is imperative that I also speak about Pakistan's law on blasphemy. This is one of the most controversial and notorious laws that were imposed by the military dictator in 1980s. This is a law that was added to the British colonial laws on laws against religion in the Pakistan Penal Code, and I think Indian Penal Code has still the same law as we have. Same in Sri Lanka. The colonial law was for the protection of all religions. And it said, 295 section of the Pakistan Penal Code, yours 291, that no one can insult another religion or destroy the places of worship of another religion. It was not specific to one religion. So this, in many ways, could be seen in the current scenario as a law which became the foundation for hate speech, for inspiration, incitement to violence, etc. In Pakistan, now that whole chapter of religion, offenses against religion, looks very different, with the addition, amongst others, of a section called 295C, which is more popularly now known as the blasphemy law, where a law has been brought in specifically to protect the Muslim faith. This law applies to any word written, oral, or by any sign that shows any kind of derogatory attitude or approach towards the respect for the Prophet of Islam. It has no mens rea in it, which means you may say something without the intention of committing blasphemy. It depends on the subjective view of the listener about what you have said and to get you declared as a blasphemer. I perhaps am today one of the very, very few lawyers who dare to take these laws and defend those accused of blasphemy. Because when we are in the court, whether it's the lower trial courts or the Supreme Court, there is a gathering of the religious extremist groups outside the court threatening us. Lawyers have been killed, saying that those who are defending blasphemers are blasphemers themselves. The courts have not supported us. The courts have not given any judgment wherein the protection of lawyers has been specifically mentioned. They have not given us protection when we are attacked in the courtrooms, verbally or physically, by lawyers themselves who belong to extremist groups. So where do we put the judiciary in terms of holding a respect for the courtroom itself when they're listening dumbfounded and in fear to threats that are being made in their courtroom? So these are some of the things that disturb me. I have, in my 45 years, and 30 of those I have spent practicing in the Supreme Court, have always respected judges, regardless of what I think of them individually. I have always criticized judgments, and many of my colleagues, senior colleagues in the bar, have criticized judgments in a very constructive manner. Because I believe that by being elevated as a judge, how much time do I have, Lakshan?
You have time till 10:30, and we can go for about 15-minute Q&A.
Okay.
There won't be any Q&A if anything.
All right. So I just wanted to kind of unburden my own grievances on you. But the thing is that when these kind of incidents happen, I keep in mind, of course, that whatever, however I may think whatever about a particular judge or not, disrespecting a judge in a courtroom is not disrespect for that person, but disrespect for the Supreme Court. At the same time, one of my grievances in the current atmosphere and environment in the Supreme Court in particular, being the apex court, being judges who have gone through several years of experience as judges, the same respect that judges demand for themselves must be afforded to every lawyer that appears before them. So these are some of the things with regard to their ability and their personality that would eventually give credence and more credibility and more trust in the institution that they are running. I think over the years I've seen that deteriorate. misconduct by judges is not taken into account. Judicial institutions that have been created for the accountability of judges have a very limited scope and does not broaden that scope to include their deliberate deviation from the principles of a constitution where their role to protect human rights, democracy, the rule of law is enshrined, and they take an oath under that constitution. That is not a ground that will become the reason for holding a judge accountable. That is not misconduct. And that is where this accountability for not upholding human rights, rule of law, and democratic values suffer when judges knowingly and deliberately violate those principles because of a lack of independence, because of influences, or because the agenda of authoritarian regimes is supported by the judiciary itself. My experience tells me from Pakistan, and we have several examples of that to put forward as evidence, that this is not just a lack of independence because of influences or pressure by the executive or the military, as in our case. This is also complete collaboration by the judges to that agenda. And that collaboration has led us into many crises that the judiciary has faced from time to time. A distrust in their independence today is widespread, and that affects the acceptability of the judgments that they give. Today we are in a situation in Pakistan where the Supreme Court is totally polarized, is totally divided on political lines. We are in the unfortunate state where we have a government and the military glorifying what they term as a hybrid system. Now, I really question that. Where does the Constitution of Pakistan allow a hybrid system where the military and the civilian elected government can jointly govern and have the equal power to decide on every matter, including the passage of legislation? The Constitution has no concept of a hybrid. And this is the Constitution under which the parliamentarians have taken an oath, and the military has taken an oath. But they keep using the word hybrid, 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 because repetition, they think, will make it more acceptable and more of the norm, where population will not even think about the Constitution and the deviation from the Constitution, even by using the term hybrid. So these are some of the things that the judiciary has also helped and contributed towards normalization of something that is totally unacceptable by the Constitution, and a very blatant violation of the Constitution. Under Article 6 of the Constitution, which deals with high treason, such an approach towards governance could very well be high treason under the Constitution. So these are things that nobody is taking note of, sitting on the bench. And it is not just this regime that we have currently, the government. The government previous to that one was blatantly glorifying what is they call the hybrid system, and the word hybrid system actually was introduced by the Imran Khan regime. Where do we as people enforce firstly the recognition by the judiciary that this is a deviation from Constitution, a deviation from the basic structure of the Constitution, and a deviation to the principles enshrined in the Constitution that include the principles of upholding human rights and fundamental freedoms, and adhering to what the Constitution says about governance. How do we firstly ask the government, the judiciary, to recognize it? And secondly, to take some steps. I was old enough in 1973 when this Constitution that we have today was enforced and was developed. I overheard many conversations between the politicians who were writing down the new Constitution in 1973. And I remember vaguely many discussions about one particular article of the Constitution that gave the judiciary, the Supreme Court of Pakistan, original jurisdiction to hear matters of public importance where the enforcement of any of the fundamental rights was in question. That served us well, that jurisdiction, in terms of public interest litigation for the protection or collective rights of people. And several cases that I have done were directly in the Supreme Court under that particular provision of the Constitution. The Supreme Court also had the power to take suo motu notice of such matters and bring it before them where a matter was of public importance and involved the enforcement of fundamental rights. The Supreme Court in Pakistan time and again used this article, which is Article 184(3) of the Constitution of Pakistan, to settle political matters selectively, to take over executive power where they felt they needed to in many ways manipulate the composition of the parliament. The result was that under a very controversial recent amendment to the Constitution, the power of the Supreme Court to touch these matters under Article 184(3) were constrained. So the judiciary itself had given a government the justification or the opportunity, let me say, not justification, but the opportunity to constrain the ability of the apex court of Pakistan to promote and protect collective rights in accordance with the constitutional provisions. And that is where the judiciary should be held accountable. The Pakistan Constitution created a Supreme Judicial Council whereby complaints can be filed directly to the Supreme Judicial Council for misconduct. But misconduct, as I said, does not include accountability for judgments where there has been a blatant effort or attempt by the Constitution to violate constitutional principles, to take political stands, There was a recent judgment in the Pakistan Supreme Court. I won't go into much detail because the end result is still to be seen, where a majority of the bench, a full bench of the Supreme Court, hearing a political application, totally ignored the law and all principles enshrined in the Constitution in order to decide whether a political party was entitled to certain reserved seats. This majority judgment appalled me. And by the way, this majority judgment was given by judges who are known for their competence, who are known for their understanding of human rights and fundamental freedoms, and how the constitutional principles apply to the enforcement of these rights. They totally ignored it, gave a judgment in favor of a political party, and they had the temerity to write in the judgment that all the wrongs that this political party has committed and their failure to comply with the laws that entitle them to these reserved seats should be overlooked because it's a popular party. So, I see that with horror as promotion of populism, which we as human rights defenders have seen growing and increasing all over the world. This populism, which has prevented judges, legislature, civil society, even in some instances, for respecting democratic values, democratic principles, and only remembering and citing as a justification for them to deviate from democratic values, saying, democracy is a rule of the majority. It is not. Democracy comes with a package of principles. Where principles are missing in the concept of democracy, it is no democracy, even though the majority may support a particular decision. And these are the people who, like some judges, think that numbers give you wisdom. Majority can only have the impact that it was supposed to have on people's abilities, capacities to participate in governance, to make good choices, only if they are well aware of the principles that democracy must be imbued with to be called a democracy. Many of us sitting here, especially those with gray hair like me, know that this topic has been debated throughout South Asia for a long, long time. Are elections the basis of democracy? No, they are not. So these are some of the things I think that the judiciary has also contributed to. If the judiciary can give a judgment that glorifies populism, that justifies deviation from constitutional principles and the rule of law, to make space for populism, that is not acceptable. And this is where we have to learn the lesson from our neighbors. Now let me take 5 minutes just to give what I expect from gatherings like this. I can talk to you, I've spoken to you for almost an hour now. Everybody knows what I've said. Everybody has some experience that matches the experience of my country from where I have given you examples. That's not the essence of this workshop. The essence is, what do we do now? What do the bar associations do as the most organized section of the civil society to make sure that we have a strategy, firstly, in the forums that are more accessible by us, be they courts or the Bar Association itself, influencing legal reform, influencing the legislature, and in particular, making sure that the constitutional principles are adhered to. I am against the theory of basic structure because it's like fitting the head into a cap. We have to have caps matching the size of the head. Societies change, politics change, nature of populations change. The Constitution cannot rule us well unless social, political, and economic realities are accommodated in the Constitution when the need arises. Yes, no constitutional amendment should take place when there are bad intentions. The bona fides of a constitutional amendment should always be of public interest. And yet, I think constitutions cannot be rigid and inflexible. Constitutional amendments should be allowed to the Parliament, but no constitutional amendment, actually not even a change in a particular law or the adoption of a political law, should take place without a wide public debate. So these are some of the things that are big challenges for us as lawyers. Yet, we have a duty, and not just the inclination. We have a duty that binds us to educate the judiciary, to educate public opinion and public sentiments in order that the principles of democracy do not go missing in the fog of populism, in the fog of extremism, in the fog of social biases, and in the fog of what yet remains in terms of social reform to make us a more civilized societies. Never ignore the fact that it is not leaders alone that create a political environment. It is how the population thinks that also creates the environment in which laws are adopted, in which human rights are respected. So, as the civil society, educating public, enforcing in some ways a sense of adherence and the importance and significance of human rights is our duty as the civil society. Lakshman spoke about many things that supposedly I have done in my life. One big failure that I, including human rights defenders from my generation, is to perform our duty well of imbuing the values of human rights and the correct understanding of democracy amongst the public. We have not been able to do that. Populism has won over our efforts to do it. So more effort must go into that. Lawyers must explain why a particular law or a constitutional amendment is to be opposed. Politicians must stand up in the parliament if they are there and resist such legislation. Parliament must resist pressures outside of the parliament, from outside of the parliament, whether it is the military or the religious lobby and extremism. They must resist this collectively. And that must be a commitment. Unlike what is happening in Pakistan, we have a parliament, a government that has surrendered to outside influence, to the security sector in Pakistan. We have an opposition that is not just irresponsible, it is vicious. It is part of the whole scenario where institutions have been divided, polarized. The respect for remaining within their domains by the executive, the judiciary, and the parliament has been eroded. So the whole concept of separation of powers has gone. So we are stuck in the middle of that. If we criticize authoritarianism that is increasing in terms of the governing regime at that time, it doesn't mean that we are supporting anything that the opposition is saying. Because we have no justification to support that, because they are also eroding democracy and the value of, and increasing the value and support for authoritarianism. This is a difficult moment for any country where the civil society now has a larger role. And amongst the civil society, because a lot of legal issues are underlying what is wrong in terms of our expectations from the judiciary, etc. The lawyers have to be a part of the civil society very actively. We saw that in the 80s in Pakistan. Lawyers were in every demonstration that the civil society was holding, or not all the lawyers, but several sections of the bar were there, whether we were opposing enforced disappearances, whether we were opposing discriminatory laws, whether we were supporting gender justice, whether it was a trade union demonstration against the right to work, or the peasants' movement. So I think this kind of a collaborative effort by the civil society is now needed. Lawyers have to energize themselves to do more pro bono work. Even individual cases, which you take as to give legal aid, contribute to the protection of collective rights. So these kind of things, I think the bar should make sure that it makes provision, it provides resources to lawyers to do responsible pro bono work and give legal aid protection for people to have access to justice, especially those who are the more marginalized communities like minorities, whether they are ethnic or religious minorities who are being targeted as an agenda of the state, or they are women, children, old people, disabled peoples. These are some of the things we need to do. And I can tell you, we may not have got good judgments in some of the cases that we took to court, but I can tell you our judiciary today, right down from the lower courts to the Supreme Court, cannot ignore us today. And this is also one of the, let me say, victories of the women's movement. In the 25 years of struggle, we finally achieved a judicial mind that was totally changed. And I'll give you the example of honor killings, for instance. There was a time when I was sitting in court, and this anti-women sentiment would be written in judgments. And words you can still find in those old judgments saying, women are the temptresses, these frustrated divorcees. Today, no judge dares to utter these words. We have seen more and more cases where sensitivity towards gender justice is coming. Gender violence is now being dealt with in a more sensitive way. We are still not there. But as I keep saying, I believe more in my struggle than achieving a goal. The goal will ultimately come. But the strife we go through is absolutely essential. If we give up the struggle, there is going to be no hope. For as long as we are willing to struggle, the hope is still there that we will change something. So thank you very much. I'll end on that note.
Thank you very much, Sheena. I think such an inspirational speech. And it was a real keynote address, and then it's also setting the tone for the entire conference for the next 1.5 days. And we can expect more from our neighbors and those who are with immense of experiences. And Hina, I mean, you are a firebrand. So, and we want the young generation to follow someone like Hina. And I'm very much thankful for Diksha and Sahar to brought these eminent people to introduced to the Sri Lankan legal fraternity and to the Bar Association. Ladies and gentlemen, with this note, I wind up the keynote speech session, and then we can go for the morning tea. And please be here by 11:10, and there will be few speeches from guests, and also the President of the Court of Appeal will be here. Thank you very much. Please be here by 11:10, and refreshments are on the second floor. Either you can walk or you can take the lift, and the washrooms are in the ground floor as well as in the second floor if anybody wants to use. And please register yourself with your committee member or not, or even invitee. And also there are little docket, and also during the workshop and conference, we will get some handouts, and we will share those handouts with you. And also, the idea of this workshop or conference is to follow and get inspiration of these eminent people from our neighbors, and practice practically in our own territories. Thank you very much.
Check. We welcome you all back after getting refreshed. So our next segment features 3 distinguished speakers. I invite all 3 of these speakers on to the head table. Firstly, Mr. Rajiva Amarasuriya, President of Bar Association of Sri Lanka. Mr. Mark Andre, Resident Coordinator of the United Nations in Sri Lanka. And also, Honorable Justice Rohantha Abesurya, President's Counsel, President of Court of Appeal. Ladies and gentlemen, let's give a round of applause and invite all 3 distinguished speakers onto the head table. May I first invite Mr. Amarasuriya to address the gathering. Over to you, sir.
His Lordship, the President of the Court of Appeal, Honorable Rohantha Abesurya, President's Counsel, Mr. Marc-Andre Franch, I hope I got the name pronounced correctly, Resident Coordinator of the United Nations Organization in Sri Lanka, Honorable Hari Prasad Huyal, Justice of the Supreme Court of Nepal, Honorable Dibanaz Fahmy, High Court Justice of Maldives, Madam Hina Jilani, Mr. Colin Gonzalez, and Mr. Anik Haq, Treasurer Bar Association, Mr. Pasindu Silva, Mr. Lakshan Dias, the Chairman of the BASL Human Rights Committee, together with co-chairpersons, Mr. Prasanta Arahampat, Mr. Rohana Muthumala, and convener, Ms. Swastika Adulingam, and co-conveners, Mr. Akram Wasim, Mr. Rajendra Narang Kandegadra, and Mr. Lakshan Vijayawardena. Ladies and gentlemen, a very good morning to all of you. Today is an important day for the Bar Association of Sri Lanka. When we convene and hold this two-day summit of sharing experiences in relation to human rights of our neighboring countries. When I met His Lordship Justice Rohantha Abesurya a couple of days ago, he reminded me about the importance and significance of SARC law in years gone by. And in fact, his father, Mr. Ranjit Abesurya, a former president of the Bar Association, whose picture is in the hall, was the president of SARC law. And that relevance and importance we all appreciate very much. And if you look at the composition of the resource persons, the panelists, and the participants of today, SARC is very well represented. And when one looks at the countries that represent SARC, Afghanistan, Sri Lanka, Maldives, Bangladesh, India and Pakistan, and Nepal, and of course Bhutan, we see that out of the 8, 7 have had turbulent times in the last 5 years. I speak of my own country, Sri Lanka, where we went through an economic crisis, and all of you have heard and witnessed that. At the beginning of that crisis, in fact, I was at the tail end of my tenure as Secretary of the Bar Association. And at that time, when both the then President, Mr. Saleh Piris, and myself went to our executive committee, I think it was about September, October the previous year, and said, well, things don't look too good on the economic front. The Bar Association needs to say something. It was a view at the time, initially, of the executive committee that, well, this has to do with economics. This has to do with the other side. And we are the Bar Association, which represents the legal fraternity. But both Mr. Piris and I were of the view that the Bar Association has a larger role. The executive committee wanted us to first speak with the Ceylon Chamber of Commerce, which is the premier chamber in Sri Lanka, and ascertain their views before we said anything or did anything. And we convened that meeting. And our fears were confirmed. And then we thought about it a little further. And then it was our view that if there was going to be an economic crisis, a country becoming bankrupt, that has direct relation and nexus and consequence to rule of law and human rights. And ladies and gentlemen, that is how the Bar Association justified its intervention both before the economic crisis and thereafter during the crisis. as someone spoke recently, the legal profession, and I speak for Sri Lanka, is like the spine or the spinal cord of this nation. We have 26,000 members across the length and breadth of our beautiful country. The Bar Association, the legal profession, the system of administration of justice and lawyers play a pivotal role in the progress of this country. Whenever there has been a crisis, whenever there has been an issue, whenever there is something positive, if one looks a little further, you will see lawyers at the helm. So it is in that context that the sharing of experiences of these South Asian countries becomes vital. If you take Afghanistan, we all know the difficulties and unusual situation we have in Afghanistan. Sri Lanka I spoke about, we all know the problems. Maldives have had problems, and we also, I think, a few months back issued a statement in support of Law Asia and the Commonwealth Association, because things which should not happen, happened. Bangladesh, we know the crisis. Bangladesh supported us during the economic crisis, and soon thereafter they were in crisis. India and Pakistan have problems, and now Nepal had a most recent problem. Bhutan has a different index, the happiness index. So far, we have not seen or heard of any issue there. I'm told the king is very concerned about the traffic in Bhutan, and that is what he had mentioned to one of our chief justices when they visited. But out of the 8, 7 have gone through turbulent times in the last 4 to 5 years. In that context, we must also look at what the world is looking at. The world is now spotlighting the global south. That is where the engine of growth is. And that is where the next century will place its priority. But whilst that spotlight, economic development, growth, human indices, all of that, we have problems in our side of the world. And as I mentioned, I speak for Sri Lanka, but I believe it applies in the other jurisdictions as well. The legal profession is that spine or spinal cord of the nation. And this is where we need to now get together, strengthen our alliances, connections, share our experiences. What happened in Sri Lanka happened in Bangladesh, and it happened in Nepal. There is a common thread which runs in this region, and as a legal profession, as leaders in this arena, we need to re-establish or reconnect with each other, share our experiences, and that is what this forum today is providing us. So apart from the discussion that takes place today, and of course the deliberations, and of course I hope a white paper at the end of this, I hope the connections, the connectivity will continue. And let us exchange our views, ideas. If any of our jurisdictions have difficulty, let's reach out to one another. And then we will have maybe statements issued by those bars, the people come in, you might have observers, and of course under the auspices of the United Nations. And that is what we are looking at for the world. And we need to come together, we need to hand over a better, more progressive, more developed region, a world to our younger generation. I don't want to take too much longer. We have our President of the Court of Appeal and the UN representative to speak after me. So thank you very much to all of you who have come from the region. Recently, Sri Lanka was identified as the most beautiful country. So if your period of time here is short, invitation to you to please come back. And when you do come back, we will also arrange something here at the Bar Association for you to share your experiences and knowledge with our membership. Thank you very much to the organizers, and thank you very much to all of you. And let's look forward to some very positive deliberations today and tomorrow. Thank you.
Thank you, Mr. Amarasuriya, the President of the Bar Association of Sri Lanka. May I now invite Mr. Franch, the resident coordinator of the United Nations in Sri Lanka, to share his remarks. The podium is over to you, sir.
My God, I almost had a heart attack. I don't know, we're less and less the United States. But thank you so much. And of course, President of the Bar Association, President of the Court of Appeal, honorable members of the Bar Associations, distinguished attorneys at law and guests from all over the region. I'm really grateful for the invitation to say a few words this morning, and especially for the great level of tolerance that you have in inviting somebody who's not a lawyer. I think I am the only one here not a lawyer. So I applaud your tolerance in allowing me to say a few words. I really commend the Bar Association for convening this really important conference to learn from our neighbors here around Sri Lanka, but also to strategize. And I think and I hope that this conference can be about action, about how we work together to have a greater impact in upholding human rights and holding the line, the moral fiber that is so necessary today in the region and across the world. And I certainly, you've described it a little bit, President, but the Bar Association really played a critical role here in Sri Lanka recently. You know, the Bar Association represented hundreds of clients pro bono that were detained during the Aragalea in 2022. And of course, most recently, the Bar Association was a really important advocate for calling for investigations, accountability into grave human rights violation. It's a particular honor for me to have Hina Jilani and to listen to her this morning. Her speech resonates quite a bit, not only in Sri Lanka, but I think today around the world. Many of us at the United Nations have and continue to have a lot of inspiration from her work at the United Nations. You've cited a few, but just to mention her leadership at the International Commission of Inquiry of Darfur. And I've had a pleasure to work when I worked in Pakistan for many years, and I had the pleasure of working with the Legal Aid Cell, which is the first all-female legal aid practice in Pakistan that she established with her late sister Asma Jahangir, who remained, when I was there, a great source of advice, of wisdom, and of humor, if I must say. And so I remember her particularly today. And I really appreciate all the courage and the sacrifices that both of you made in Pakistan and continue to make, and also the lives that you've helped transform over there. And so wonderful to have you here and to join such illustrious guests from all over South Asia. And South Asia has so many inspiring examples of lawyers and judges who have helped set legal precedent, shape reforms, and defended human rights. From I.K. Gujral, former Prime Minister of India, to Asma Jahangir in Pakistan, Kamal Hussain in Bangladesh, Devendra Rajpande in Nepal, and of course here in Sri Lanka, Neelam Tirushelvam. These lawyers and jurists remind us of the courage and the sacrifice that is required to uphold justice. Many lawyers in the region continue to face intimidation, harassment, and violence when defending fundamental freedoms. And this makes your work and your strong bonds of solidarity, President, that you've called for in these very difficult times with one another, even more important. As human rights lawyers, you have special rights and protections under the International Covenant on Civil and Political Rights that Sri Lanka has ratified. And we need to make a lot more efforts to ensure that lawyers who are at risk are protected from reprisal and political interference. Human rights and good governance go hand in hand. Without rule of law, strong institutions and effective courts rights mean very little for people. Lawyers are central in this system. As advocates, you have an ethical duty to defend clients' rights, of course, uphold justice, protect freedoms guaranteed in the constitutions, and in accordance with Sri Lanka's international human rights obligations. During the recent visit of the United Nations High Commissioner for Human Rights to Sri Lanka a few months ago, he highlighted some of the key human rights challenges in Sri Lanka, including the right for truth and justice in the context of several decades of allegations of enforced disappearances, the lack of accountability for serious violations and abuses committed in the past, including international crimes, and restrictions in civic space, including the targeted intimidation and harassment of CSOs and human rights defenders. As Sri Lanka is now contends with an ambitious legal reform agenda, I really hope that the Bar Association can continue to actively take part in public consultations and advocacy efforts, leveraging your strong public legitimacy, starting with the reforms of laws like the PTA, the Prevention of Terrorism Act, and the Online Safety Act. I also hope that lawyers can take more pro bono cases for indigenous clients, especially for cases of torture, discrimination, and arbitrary detention. Your role is also critical in supporting families of the disappeared and other victims as part of investigations of mass graves and in the expedition of emblematic human rights cases. I encourage the Bar Association to deepen its collaboration with the Human Rights Commission and other national institutions and commissions. And I appreciate, that Sri Lanka's public trust in justice institutions has diminished due to delays, politicization, and entrenched impunity. So together, the Bar Association with other national institutions like the Human Rights Commission can really effectively advocate for the protection from reprisal, justice, legal independence, and enforcement of laws and implementations of human rights treaties, bodies through the domestication to address the lack of accountability. The United Nations were committed in continuing to support Sri Lanka in strengthening justice, accountability, and the rule of law. And today we're particularly invested in improving access to justice, facilitating solutions for the justice sector, improving the development and implementation of new labor policies, accompanying the Human Rights Commission, and also supporting legislative reforms to align with international human rights standards with a particular focus on the PTA, the OSA, the Muslim Marriage and Divorce Act, and the CSO Act. In closing, I really hope that these next 2 days will be very beneficial and that you can strengthen those bonds of solidarity. And while sadly I'm not a lawyer, or at least not yet, I can't tell you how important it is, how important your work is for the future of the country and the region, and how important it is to count on a strong network of regional allies and experiences. Thank you very much.
Thank you, Mr. Franch, for sharing your thoughts with us. I now take the honor of inviting Honorable Justice Rohantha Abesurya, President's Counsel and the President of the Court of Appeal, to share his wisdom with us all. Ladies and gentlemen, let's give a big round of applause and invite Justice Rohantha. Over to you, sir.
Mr. Rajiv Amrasurya, President of the Bar Association of Sri Lanka, Your Excellency, the resident UN coordinator in Sri Lanka, distinguished delegates from our neighboring countries, eminent jurists, learned members of the bar, and ladies and gentlemen. Now, when the UN resident coordinator was introduced, there was a slip of the tongue. And he was introduced as a gentleman from the United States. When I was seated at the head table and listened to his very illuminating speech, I thought his voice sounded a little bit like Mr. Donald Trump. Mr. Amarasuriya prefaced his address by referring to the SARC law concept and the organization which was known as SARC law, which I believe is still in existence, and I'm quite proud of the fact that my father was one of the founding members of SARC law. I have very pleasant memories of my visits to various countries to attend SARC law conferences, and I had a bit of an unpleasant experience in Pakistan. I think the conference was held in, if I'm not mistaken, Marriott in Karachi. I'm not too sure whether there is a Marriott hotel in Karachi, but I think I think it was Marriott in Karachi. I lost my passport because I think hid it somewhere, and I simply could not remember where it was. When I came back to Sri Lanka, of course the embassy intervened and I was given a temporary passport. I found the passport inside one of my shoe boxes. I usually store shoes in boxes because somebody gave me, somebody told us that sometimes people steal passports, hotel staff. So that was a bit of an unpleasant experience I had in Pakistan. But my father was extremely passionate about the concept of SARC law in general and SARC in particular. Unfortunately, he's not among the living. He would have been extremely sad to see what's going on in some of our sister nations around Sri Lanka. Ladies and gentlemen, it is indeed a privilege to address this gathering at the South Asian Regional Workshop for Human Rights, organized by the Bar Association of Sri Lanka in collaboration with the United Nations and South Asian for Human Rights. I extend my heartfelt appreciation to the BASL Standing Committee on Human Rights for taking the initiative to bring us all together under this timely and meaningful theme, learning from our neighbors. In any civilized and democratic society, the true measure of governance lies not merely on the might of the state, but in the protection and promotion of human dignity. Human rights form the bedrock upon which democratic institutions are built. They are not abstract ideals. They are the living principles that guarantee freedom, equality, and justice to every individual. As the United Nations has defined in the Universal Declaration of Human Rights, and I quote, "Human rights are rights inherent to all human beings, regardless of race, sex, nationality, ethnicity, language, religion, or any other status. Human rights include the right to life and liberty, freedom from slavery and torture, freedom of opinion and expression, the right to work and education, and many more. Everybody is entitled to these rights without discrimination." End of quote. The definition reminds us that these rights are not granted by governments. They are inherent, universal, and inalienable. The role of the state and the judiciary, therefore, is not to create them, but to recognize, protect, and uphold them. The constitutional order of modern democracies, including our own, rest firmly on the recognition that sovereignty belongs to the people and that the state exists to secure their rights and freedoms. When we speak of the rule of law, it is inseparable from the recognition of fundamental rights. A judiciary without human rights is a hollow institution, for its legitimacy springs from the assurance that justice will be administered fairly, equally, and with due regard to the dignity of the human person. Throughout history, we have seen that societies that disregard human rights ultimately compromise their legitimacy, their stability, and even their very existence. By contrast, those that safeguard human rights, even in times of adversity, emerge stronger and more resilient. This is why the judiciary has an unshakable responsibility not only to interpret the law, but to be a guardian of human freedoms. Human rights also serve as a moral compass in governance. They restrain arbitrary power, they protect minorities from majoritarian dominance, and they give voice to the vulnerable. In essence, they remind us that the worth of a society is measured not by the power of the state, but by the security of its citizens. As judges, lawyers, and advocates, our calling is to uphold these values. Our task is to ensure that the courtroom becomes not merely a forum for legal debate, but a sanctuary for justice, where the principles of equality, liberty, and fairness are not mere words, but daily realities. In this regard, gatherings such as this are invaluable. They reaffirm our shared commitment to the principle that justice without human rights is no justice at all. Distinguished colleagues, while human rights are universal, their contextual challenges often vary by region. In South Asia, with its rich history, cultural diversity, and complex socio-political realities, we face unique struggles, but also unique opportunities. This brings me to the significance of regional cooperation. The creation of SAARC, the South Asian Association for Regional Cooperation, was rooted in the belief that our nations, bound by history, geography, and shared destinies, could achieve more together than in isolation. While SAARC's political trajectory has faced challenges, the spirit of intra-regional dialogue remains vital. In the field of human rights, too often we look towards the West for models and precedents. Yet, our own region is replete with rich experiences and jurisprudence that deserve to be shared and studied. From constitutional courts in India to transitional justice mechanisms in Nepal to pioneering judgments from Pakistan, Sri Lanka, Bangladesh, and the Maldives, we have much to learn from one another. The workshop exemplifies that vision. By drawing parallels within our region, by exchanging experiences, and by developing regional jurisprudence, we can create frameworks that resonate with our own cultures, values, and societies. More importantly, such intra-regional cooperation can pave the way for stronger solidarity, ensuring that South Asia speaks not with many fragmented voices, but with a collective voice in the global discourse on justice and human rights. I once again commend the Bar Association of Sri Lanka for its foresight in convening this workshop. It is my hope that the bonds we build here will endure beyond these 2 days, and that our shared dialogue will inspire us to reaffirm our role as guardians of justice and defenders of human dignity. Let us leave here with the conviction that human rights are not merely legal entitlements, but the essence of what it means to live in a truly democratic society. And let us remind ourselves that as neighbors in South Asia, we have not only the opportunity, but the duty to learn from each other, to support from each other, and to build together a future founded on justice, peace, and human dignity. In conclusion, I'm reminded of the famous statement by that great human being, Nelson Mandela. To deny people their human rights is to challenge their very humanity. I thank the Bar Association for inviting me and wish the Bar Association and all of you all fruitful deliberations. Thank you.
I would like to thank Honorable Justice Rohantha Abesurya, President's Council, and the President of the Court of Appeal of Sri Lanka for his thoughtful words. And I also like to thank all three esteemed speakers for their inspirational speeches. We now move on to panel 1 on the critical role of the judiciary against discrimination and violence against minorities. Our distinguished panelists are Honorable Hari Prasad Puyal, Justice of the Supreme Court of Nepal and former Attorney General of Nepal, Honorable Deebanas Fahmi, Justice of the High Court of Maldives and the first female judge to sit in the Criminal Court of Maldives. The session will be moderated by Mr. Jagat Kularatne, Attorney at Law Sri Lanka. I now hand over the session to the moderator.
Good morning to everyone. Our topic for this panel 1 is the critical role of the judiciary against discrimination and violence against minorities. We are privileged to have two eminent judges with us, being our panelists. Justice Hari Prasad Puyal, he is a Supreme Court Judge of Nepal since April 2019. He previously served as Attorney General of Nepal, and he has experience, worked with UN Office of the High Commissioner for Human Rights as National Legal Advisor in 2005-2006, focusing on constitutional, criminal justice and human rights issues. If I mention his academic career, he has taught jurisprudence, human rights, banking and commercial law at Tribhuvan University. He authored works in refugee law and human rights law. He holds 2 master's degrees, one in international human rights law from University of Essex and another in business law from National Law School of India, University of Bangalore. The other panelist, Justice Deebanas Fahmi. She has been serving in the High Court of Maldives since 2022. With 17 years of experience in the criminal justice system, she made history in 2020 as the first female judge appointed to the Criminal Court of Maldives. Previously, she served as Deputy Prosecutor General before joining the bench. She holds LLB from International Islamic University in Malaysia and LLM from the University of Canterbury, New Zealand. Now I invite Justice Hari Prasad Fuyal to make your preliminary remarks. Yes, please.
Thank you so much, dear panelists and distinguished personalities from this region, judges, President of the Bar Association and legal fraternity from Sri Lanka. I'm happy to be here to speak on the topics. I will divide my presentation in two parts. One, that I will speak on the role of the court on the given topics, and I am asked by the organizer to share some experience on Nepal, what happened recently. So I will speak on that part at the later time, end of my presentation. So first, on the role of the judiciary against discrimination and violence against minorities. Let me begin with the context of Nepal. In 1990, we had a constitution after a pro-democracy movement, and that included mostly civil and political rights, and we ratified a number of international human rights treaties, and we made a Nepal Treaty Act giving the superiority position of the international law in case they collide with the national law, not with the constitution but other national laws. So based on those ratified treaties and the fundamental rights provided in the constitutions, and we had a provision of public interest litigation that was built by the judicial practice from India as a part of the constitution, that any person can bring public interest litigations if they are directly related to the subject. So that allowed a number of public interest litigation, and first wave of litigation actually came from protection of women right perspectives. In a famous case called Mira Dhungana versus government of Nepal, it was about right to partition like a son. After a huge debate socially, after filing that case, and in the court, a number of days arguments, court finally decided to give partition right to women, recognizing both son and daughter are as equal status. And that opened up a number of scope for the litigations, and like another famous case, Sapana Pradhan Malla versus government of Nepal, that is on the marital rape. It was not, when the case was filed, there was a huge debate, including in the legal fraternity, including among the judges. So the court finally decided, yes, that can happen and it should be criminalized. So that actually went further. And there was another case, we had a Nepal Airlines Corporation, and the women staff were asked, were written to retire earlier than the male staff, and that was challenged. And court said that no, this cannot be done. This is, this violates right to equality, CEDAW that we had signed, and number of other international and legal obligations. So these things actually brought number of issues before the government, but they were not implemented. They were just passed by the government, court, and these were mandamus. Some of them were directive orders, and there was a huge pressure to implement those mandamus and directive orders. So the cabinet decided to take the bill to the parliament and amended the act. So number of these became part of the act. So there are so many cases on women's rights, perspectives to make them equal in the society. And later on, we had a long armed conflict, and that has overthrown the, the kingship, and we had a new constitution, 2 elections of the Constituent Assembly, and finally constitution was promulgated in 2015, and all those rights actually were incorporated in the new constitution as a fundamental rights, as a women rights, as a equality rights, as a children rights, as a health rights, or number of other rights. And there are like other cases, for example, on protection of minorities and indigenous community. A number of cases were filed in the Supreme Court, and most of the cases Supreme Court issued mandamus or directive orders, like to let them choose their language they want to speak in local school, and to let them choose how they want to celebrate their local cultural functions or festivals. So like on environmental issues, protection of indigenous community, when there is a big electricity dams were made, were protected, they should be consulted first. And if relocation has to take place, it's not only the people, their culture, their aspiration of that particular place, that kind of things were ordered by the court. And actually these were the foundation of right to environment and balancing with the minority people's right. So therefore, based on those all mandamus and directive orders of the Supreme Court, law was changed, environmental international obligations were ratified and law were changed, and finally these things were incorporated in the constitution as under right to environment under 2015 constitutions. Under the protection of Dalit rights, people were not allowed to go certain temples. So case was brought before the court, and court ordered that no, there shall be no discrimination on entering the temple. Whosoever is that person, if they believe in that particular religion, they can go and enter and worship. Like there were restrictions on being priest or going to hostel, like certain people were, and going to like Sanskrit schools, restrictions for particular communities, especially from the Dalit communities. Case were brought before to the court, and court said no, you cannot discriminate someone to go in particular hostel, particular temple, or to go to particular Sanskrit school because of your caste or touchability or untouchability issues. So these kind of, and the other front, like on disability rights, like people challenge on accessibility to courts, on accessibility to government buildings, those who are disabled, and like their participation in the government systems. And they were all positive orders by the court, based on right to equality and non-discrimination, to allow them and to amend the laws. An international treaty was like ratified, and a different law was promulgated with the parliament, and now the new constitution has all these fundamental rights. So the court on protection of human rights, on the inclusive issues, like inclusivity, like people belongs to different community and there's a lot of diversity. So what there were petitions on the equal participation of different community in government structures, including in the court. Court said yes, based on the number of populations, there has to be certain among the competent people, some quotas they can compete, and particular post will be filled from that particular community. The court played positive role on that, and these are now part of the new constitution. So there are a number of, actually, if you look at the global rule of law index before the event, the recent event, we were topping on the independence of the judiciary in South Asia, we were topping on rule of law, and we were topping on progressive judgments from the court. We we were handling the issues. We had a number of issues. There was a big backlog in the court, especially because of the, some tensions in the border between Nepal and India. There was a, blockade, and we had a big earthquake. Most of the court's buildings were devastated. And then we had coronavirus, and we had our own problem within the judiciary. There were 33,000 cases pending. We were actually now recently had caught in a very good tune, and we had reduced the cases to 24,000. We were planning to bring it down to 18 by next 2 years, and it was going well. So this is on the court's kind of thing. I think I would not. There is a written on sexual minorities. Actually, we were pioneer. We have a pioneer judgment from Nepal. Like there was a public interest litigation where they sought for recognition of their identity and status in 2007. We said yes, they cannot be discriminated based on their identity and sexual orientation. And there were a number of other cases, like they wanted to have citizenship based on who they are. They wanted to have passport based on who they are. And they wanted to have access to government services and other facilities. And court was always, positive on them. And even we have recognized same-sex marriage. There was an interim order. The case is still pending there. There was an interim order. You can temporarily register until the final judgment of the court. I think even after that judgment, India, Bangladesh, even Pakistan, had some progressive judgments on sexual minority rights. So we were actually we are still leading on these kind of progressive issues. So, on mental health, we have people were discriminated based on their mental health status. There are a number of laws which says that, whose mental status is not, in a right place, that person would be deprived in number of issues. And mental health was a sort of stigma, and there was no government particular budget and a sort of department within the Ministry of Health. So we have issued an order not to discriminate. All statutory discrimination should be removed. There has to be particular budget and department within the government system, in the health minister system, to provide them facility and encourage them, to come into the mainstream. So, and most of the judgments are implemented. So we actually made society to some extent egalitarian. If you look at the freedom perspective, including from right to religion to freedom of speech, we were actually doing well. So I have written, a speech. If someone is interested, I have given it to the organizer. You can go into the details. So this is my first part.
Thank you, Justice Prayas. Now it's over to Justice Devanas Swami. You can make your preliminary remarks on this.
Thank you very much. Thank you for the opportunity to speak here. And as I see that we are a bit behind time, so I will go right into what we are supposed to discuss at this panel. First of all, just to give you a bit of background so that you would have some context as to where I'm coming from. The Maldives has never been a British colony, and along with that comes some of the disadvantages too, which is that they very much left us to govern ourselves, which meant that we did not have a legal system, which was one of the things that was beneficial, that was left as part of the colonial rule. And in our situation, the first trained lawyer with a degree came to the country in 1980, which is again something that's not commonly found with all the other South Asian countries and our neighbors. So you would have to take that a lot of things that come from us is very much in light of our realities of the situation, the lack of education, the lack of a proper system, a lack of experience. But, and I have spent quite a lot of time trying to explain to people that I don't look as young as I am. I'm older. And this happens often enough. When I go to conferences, they say that you're a high court judge. Yes. But in our case, we have a very young pool of lawyers, so which meant that, in short, when it comes to the judiciary, we are young too. And it would come as a surprise, compared to other countries, that in our context, most judges get appointed immediately as soon as they come after their education. And usually our judges are from graduates of Azhar University, considering also factoring in the reality again that ours is also, our legal system comprises of not just written law, it includes Sharia law. So Azhar graduates were seen as a preference, and I'm afraid I'm a bit of an anomaly when it comes to the judiciary, and I joined the judiciary only 5 years ago, and I'm one of the few who actually came from practicing lawyers. So most of them came directly. So that's a bit of background as to the context. When it comes to fundamental rights, human rights, Maldivians are, and I think it's something that's common to all Asians, we are obedient people generally. And we think that disagreement is impolite. And that is more common, that's even more true when it comes to the Maldives. Talking about fundamental rights in our context is seen as impolite, disagreeing, and in short, someone who causes trouble. And that's exactly how it's still viewed, but I think that we have moved on from that point. It's gotten a little better, but not as much as we would all like. And the current constitution, which was came into force in 2008, that's quite recent, but it was a result of fundamental rights violation, a result of reform due to fundamental rights violations. And the current constitution, Chapter 2 Constitutional Rights, have incorporated in the concepts that we have in UN treaties and other human rights agencies. Those have now become enshrined in our constitution as something that you can get as a matter of right. But one of the aspects that we have in our constitution is that we have two classes of rights. One is the rights that you have as citizens of Maldives. The other is the rights that you have as a person who lives in the Maldives, any person in the Maldives. So the distinction of language is there. And in our case, since we are all one race, one religion, one language, with some dialects, but still it's one language. So we do not have minorities as such as what you would find in other countries in this region. And so for our topic, I would like to sort of like divide that into two classes. Firstly, how we deal with minorities in the context of migrant workers who are in the Maldives, and to a lesser extent, but still, when it comes to access to justice, women and children ought to be, I believe that they ought to be considered as minority rights holders, even in our context. And it is not always just migrant workers who are minority right holders. In our context again, when we deal with minority rights, migrant workers come again, it could be subdivided into two other additional classes. Firstly, when they are victims of trafficking, often enough, it's usual and very common when it comes to labor trafficking. The second is when they actually become offenders. So how do we as judges enable an environment and perhaps assist them as people who are not citizens of the Maldives? First of all, let's take for an example, victims of trafficking. They often have the language barrier. You might not always, in most situations, you will not be able to find people who are willing to, unfortunately, again, we have a very small criminal bar, and then very few who actually work pro bono. Because they are minority rights holders and they are migrant workers, they are not going to have much money. And we have been trying to get our bar to work pro bono a lot for minorities, especially migrant workers. And we have actually now, in the last 3 or 4 years, we have a law firm who are well known as those who assist migrant workers in any situation. So that's a huge development. And when it comes to the judiciary, what we can do, I found as a judge at criminal court, is that, first of all, they don't know their rights. And often, if it is a small offense, when they're not serious offenses, they do not get legal representation by the state and they cannot afford it. So what I had in my hand when it came to minor offenses, situations of where arrest and remand was in question, I felt that judges ought to take a bit of a proactive role, and often enough, a simple question of just asking them, do you have any other issues that you would like to tell me? And most of the time, we as lawyers and judges, we are very comfortable in the situation of in a courtroom. It's not a place that's daunting, it's not a place that's scary, it's home for us. But for anyone, especially a migrant worker who does not have the ability to speak in our own language, in a different country, a foreign country, all of this magnifies and amplifies, and it makes it very difficult for them to even articulate. And when a judge asks them, what else do you wish to say here, and you're able to freely speak, I found that there is a huge difference in their attitude and how they communicate also. So a simple example is they often do not get opportunity to speak to a lawyer as often as any Maldivian citizen would. And what I started to do was schedule my hearing so that it comes close to just before lunch. Most lawyers are willing to give up lunch for their client. We all have, and I'm sure that many of you would do just the same. And if it is at that time, and again, you need to understand our context. Our jail is on another island. The ferry is controlled by the Department of Corrections. Financially, it's got to be borne by the person who is held in custody. So in all probability, most will not be able to afford that. And if it is an online conversation, it just doesn't work the way that you would have with a person in your presence. It's not personal. It makes a huge difference. So what I did was, we all had a courtroom assigned to us, and if it is a migrant worker who is actually, that was during my time at criminal court, I scheduled those cases just before lunch, and I asked the accused, would you like some time with your lawyer? I don't even I'm sorry, I don't let the lawyer even make too much, be able to say no. But if he does, I offer them the opportunity to use my courtroom and have a conversation, because it's going to be vacant at that time. And I felt that it was a simple thing that we could do, which is not institutionalized, but I found that once I started doing that in criminal court, other judges followed. They too were able to do that. So those are simple little things that we could do. And also another thing is, again, court access to justice does not really begin inside the courtroom. It begins outside, and it starts with the person who is at the counter, the staff, the court staff who is at the counter. And it's very important for them to be also mindful when it comes to communication with any person who comes in contact with the court. Again, court is home for all of us, home for the administrative staff, but someone who comes there, especially a person from a minority right holder, like, again, someone who does not have the communication skills, it's very difficult. And again, what we could do, I found again, was anybody who comes in contact with someone from my section, my administrative staff, they were asked to ask a set of questions. Rather than just answering their questions, proactively ask them, do you need anything else? Would you like help with this? And another way that I found that we could actually help as judges on this side of the bench was, we have very limited opportunity to speak with members of the bar right now. But when we do, always volunteer. I always volunteer for training, other services when it comes to the bar. And I felt that it's the personal relationships that usually make a huge impact and creates a difference. When you have good relationships with other members of the bar, you could always find someone who might be willing to, I go and ask them, would you be willing to do pro bono work? Would you be interested? Could our administrative staff guide you towards these people? When they need someone, could we ask them to call you? And they have often given us the green light and say, okay, why don't you give my number for these types of questions? We would be happy to help them out pro bono. So because there's a huge gap in finding assistance when it comes to lawyers, legal assistance when it comes to migrant workers, we've managed to have a few members of the bar who would be willing, and we have started out handing over those numbers, contact details, to those who would like to do that. And another thing is, when it comes to victims who are again from minority right holders, such as victims of violence, sexual abuse, women who have been trafficked for sexual exploitation. Again, asking a few questions, allowing them to have a bit of reprieve once they are there at court, even before giving their witness statements, having a bottle of water, having the tissues, do you have any questions before we start? Explaining the situation, how the court process is going to go forward. All of these little things go a long way. And I found that even when especially when it comes to translation, when you, yes, you have a translator, they will go ahead and say it, but you make sure especially when they are unrepresented, ask them again, did you understand what was said? Do you have any questions? These are little things that could make a huge difference again. And in addition to that, when it comes to minority rights, and I find that women, when it comes to access to justice in the Maldives, women Maldivian citizens, and not just migrant workers, they have an additional difficulty. That difficulty is by gender alone, and that has to be taken into account. A good example would be we've had a few cases where those factors have been taken into consideration when giving out judgment. Most of the time they come unrepresented, and they don't even know what the real issue behind it is. But when it comes to judges who would like to make it may not be as properly argued as you would have liked. If they had been if they had actually good representation, legal representation, they would have been able to make a better position in court. But once those issues come up, there's always the possibility in our context, for instance, in our context for sure, I'm unsure as to how much leeway you would have here in Sri Lanka, but to address those issues, even if they may not always be what your ratio is going to be. It may not always involve the ratio of the case. It may be something that had come up, but could be really identified as a gender issue that obstructs some access to justice. One simple example was a recent decision given by our Supreme Court. Housing is just to give you a bit of context, housing is a huge issue in Maldives. And when it comes to asking for land, application for land in the Maldives, applications are made by husband and wife, and you are given point system based on how many kids you have, how many wives you have even at times. But then bottom line is, in islands, the forms for registering the land only has one slot for a name. It stumps everyone as soon as the wife wants to be registered landowner. And most of the time, the person who owns the land is going to be the registered owner. And although women usually are taken into account, when it comes to points being given for eligibility of the land, they do not always, as of right, have ownership in that land. So when it comes to a point where there is a split, when they separate, when there is a divorce, who owns the land? Now that was something that was factored in at the Supreme Court's level, and it was not brought as a legal issue per se in the lower courts, at the High Court, or even at the Court of First Instance. But nevertheless, it was something that was inherent, but it was something that was argued on the side throughout that case. The woman kept saying, I was part of actually getting this land for the husband, and I ought to have an equitable right. Although they were unable to articulate that there existed an equitable right, they were aware that they had a right. And that was an inherent thing. But that recognition did not come up until the Supreme Court made way for that. So that's one of the simple examples, and I know that we are a bit short of time and we would have opportunities for questions. I'll make this short for now. Thank you.
Thank you very much, ma'am. Since we are running out of time, I would like to open the session for the questions from the audience. So please make it short. Just raise the question without making any comments, and keep in mind that Honorable Justice Fuel is going to share his experience about the recent Nepal struggle, so we have to save some time for that also. Please.
Medhati Always, my question is for Justice Payal, you said that there has been a lot of pioneering instances and cases in the Nepali Supreme Court. We are very happy to hear that. Practically too, is that the case? That is that as much as there is legal precedence, judicial precedence favoring different pivotal minority issues, marital rape, etc. The society also, is it in line with the same phenomenon? Thank you.
Well, on next yours. Let me finish this.
Yeah.
On marital rape, now it is a part of the criminal code. A person who commits that will go 5 years imprisonment. So, and there are a number of court cases, we are deciding it and we are sending people to the prison. This is one. On sexual minorities, there are some, like opinions in the society, especially from in the religious, group. But like the Constitution says, no one shall be discriminated based on the gender and sexual minorities. There is nothing, criminalized if someone does that. But like, based on that, they receive citizenship, and the laws are changed. Even if you look at the health policy, sports policy, rest of the education policies, it's all gone. Like you cannot discriminate children if they have, it comes from the childhood level, sexual identity, like orientation. They cannot be discriminated based on that. So there are some criticism, but it was a court order. Now it is part of the Constitution. And more or less, there could be some opposition, but society has by and large accepted it.
I have a question on the relationship between the bench and the bar in Nepal, because I always think that you were mentioning the time period between 1990 and 2000s, how many progressive judgments were delivered by the bench. But in terms of the composition of the judiciary, was it always, was the judiciary always open to international developments in the international legal law, or was it something which developed over time? Because we can make as much as submissions as we want to the judiciary, but unless the judiciary is able to, understand those submissions, it's not possible to have progressive judgments, and that has been the experience in South Asia. So just interested to the composition of the judiciary at that time when all these progressive judgments were made. And I just also have a question for Justice Swamy. In terms of pro bono work, many of us here do a lot of pro bono work, but we also have this criticism of pro bono. That is, pro bono is the charity of justice, that there has to be a much more systemized way of access to justice and universal right to justice. I just wanted to hear your opinion on that aspect. Thank you.
Please, Justice Fairley, go ahead with your answer.
All right. If I understand correctly, first the relationship between bar and the courts, right? So I was a lawyer before. Mostly I practiced commercial law for my living expenses, and I did human rights work as my part of the pro bono work. And I know the kind of nature of lawyer when I was a lawyer, and now I know what is the nature of judge when I'm in a bench. So I think every country has some level of grievances, but the judges are respected. Largely judges are respected. They are criticized, from their writings, from their judgments. Like, they will not spare, if any judgment says out of track or has broken the jurisprudence or something else. And our bar association is more active in like yours, in number of human rights issues, on political movements. It's more active than the Indian Bar Association. I think in India, Bar Association is largely, it doesn't have the role like us. In Nepal, is Bar Association quite active, but the relationship sometime yes, and especially I will speak in the other session on freedom of speech, like on social media and lawyers. That I'll leave for that session. And the other issue you raised is, what was that?
The whether the Nepali judiciary was always sensitive to international developments in human rights law, or did that happen over time?
Actually, it's from 1990, and it is consistent. It is consistent. I was, like I started my practice from 1990, and it is so far we haven't, what you call, written back on human rights jurisprudence, and there are judges and there are lawyers who understands international law, international human rights treaties. Even we recognize soft laws, not only hard laws. And sometimes we receive, what you call is the judicial note, if not amicus curiae, by the international organizations. We do not refer them, we do not write them, we receive it, but we read them and rejuvenate ourselves. Sometimes we have referred a couple of amicus curiae from International Commission of Jurists. There was a famous military justice case where it was challenged that military justice should be part under the under the regular justice system. And yes, we said that yes, it is a part of its appeals should come to the Supreme Court, and it is like it is a judicial mechanism. So there has to be a separation power, investigation, prosecution, and adjudications, and there has to be a civilian judge. And we refer actually, some of the, amicus curiae notes. So the military justice system, and that decision changed the entire legislation of the military law. And now mostly actually it is in standard of the international norms. So yes, our lawyers and judges quite frequently use human rights or other international law discourse. We refer number of them in our judgments. We refer some of the judgments from Sri Lanka too, mostly from India and United States and of course UK, from Bangladesh, and some of the references are also from the Pakistan. Yes, I think judiciary is open on that. We have one article called Article 126. It says recognize principle of the justice. So we devised that particular article, recognize principle of justice, even as evolving somewhere, not directly binding to us, but persuasive to us to take a notice and include in our judgments. Thank you.
Yes, it's over to you.
Thank you. With regard to pro bono work, our situation is actually unfortunately worse. There is no system. But what I think is that when it comes to the relationship between judges and lawyers, I think we need to think a little outside the box. Just like I said, we offer a lot of we offer our services in the context of education. That's something that we as judges could do. And I feel that personal relationship, just like I said before, the personal relationship does create a difference. And it makes a difference in the context of people who are willing to come forward to do that pro bono work. And I don't think that the Sri Lankan bar has been established and has had a longer history than ours. Ours is just since our bar association was established in 2019. They're very young, but nevertheless, we're trying to inculcate in them a culture of pro bono. But at the same time, we understand that although there's a huge number of lawyers, not many actually want to practice. And when it comes to the criminal bar, there's always a reluctance. So the pool of actual practicing lawyers is very small, which means they would be overworked as it is. And considering the fact that most of them would not be getting paid, pro bono is going to be a huge challenge for them. I mean, we have to be realistic about the fact that they do have to earn a living, they do have families, they have rent to pay, they have to put the food on the table. but the number of pro bono service providers increasing will create it will make the burden not so heavy on a few, but rather a shared burden among many. And it so happened that I was at one point, before joining the judiciary, I was the consultant for a green paper on legal aid and pro bono work in the Maldives. And one of the suggestions I put forward was a recognition every year by lawyers for the person who does most pro bono work. I don't know how it is here in Sri Lanka, whether that is done. I hope it is. But that recognition creates an incentive for those who do not do pro bono work to actually come forward and contribute in that sense. It doesn't have to be many, but still that recognition by the bar that you have gone outside and beyond your normal scope of work to actually give back to the community, and we all recognize it, that is a huge incentive. It doesn't cost money, but it is something that would actually enable people to come forward to do that work. And we are trying to get that into place at our bar association, but it's not there yet. But still, what we can do, even in the absence of it, is we as judges can recognize that they do pro bono work at every opportunity we have to talk about those things. So recognition by judges that you do pro bono work and we appreciate it, that goes a long way again. So those are not systems that are structured, written down, but still makes a huge impact in this in the society. So I think that's something that could be done. But I think it's always going to be a huge challenge to have people to do pro bono work. And kudos for all of you who do pro bono work here. Thank you.
Any other questions?
Yes, a small one from Honorable